Mr. Chairman, thank you very much. The discussions have been very important today, and I think the issue is laid out where the American people know what they think is right and wrong. Discrimination, I think, defines itself in existence of law over and over and over, and it tries to give a balance, not just to the importance of it, but also about how it would be looked at by conduct. Not just the law, but really how we ought to move as a society. Attorney General Rokita, you and I have intellectually disadvantaged, disabled children. We had to fight lots of battles and still do, but we asked for accommodation. I don't think we asked for to overrule or move over. We asked for accommodation, the opportunity to participate. I note on page 10 of your brief that you gave us, Indiana State Attorney General advisory opinion concerning use of preferred pronouns in the workforce. This is very interesting because it goes well beyond something that I think someone could see on its surface, something that someone could easily understand. We can see color, we can see sex, we can see things. We know discrimination when we see it, attitude and other things. I note in here that you find it's not against the law, and yet people are held accountable. There are federal rulings on this by government, EEOC perhaps most importantly. This disturbs me. Where is the line between discrimination defined in law and this overwhelming desire for people to push simple things like pronouns or competing against women?
Thank you, Congressman. I mean, that's exactly it. You have painted the picture correctly. Title VII was very clear in the words that it used. And Bostock has taken it a very tiny step further, still connecting it to the word found in Title VII, particularly the word sex. But what the EEOC does, and the reason that the legislator who asked for this opinion wanted it, was to stop that creep, to stop that crawling by unelected bureaucrats.
I think we all need to know where the line is.
Right.
And it would be inappropriate if I necessarily meaningfully discriminate against someone, but there's a lot of things we don't know about people that we can't see that we don't know.
Right. Like whether it's our sons or in any context. And that's why the laws have to be clear. They have to be unambiguous. And that's why it's wrong for unelected bureaucrats to try to take those words, those laws that you are supposed to create, and make their own interpretations of them and then try to enforce them, which is exactly what is being done at the EEOC today, and why it's important to have opinions like the one we did in Indiana.
Mr. Stepman, I found your arguments most compelling because I believe that most Americans want to do the right thing, but they expect that the law will equally be balanced in that endeavor. And we tend to hear about how capitalism and corporations or businesses want all these things, but really what it gets down to is that I think we, deep down as Americans, want to be good to people. We really don't want to hold things against anybody, but we also recognize when that line is violated, when it didn't work for me, or it didn't work for a group of people. Tell me more about how we fix this. Is it done in state laws? Does it have to be done in a federal law?
Well, Independent Women's Voice has been quite active in, we have something called, where we basically are advancing a definition of sex, which we didn't used to have to do, right? This was something that was common sense. Everybody understood what a woman was, what a man was. But now we find that it's necessary to actually define that in state law in order, for example, to protect sports opportunities for young women. Unfortunately, this administration, in 2021, for example, we had West Virginia pass exactly that kind of law, defining the word woman and only permitting females to participate in public youth sports. Very reasonable thing for a state to do. We actually had the Biden administration come in and say, no, our interpretation, this is even before their regulatory drop of 1,500 pages, right? Come in and say, no, we interpret federal law, Title IX, to basically say, no, the state of West Virginia cannot define the word woman. So I do think ultimately something will have to be done on the federal level, and the first thing that has to be done on the federal level is for agencies to stop going beyond their mandates and usurping the job that this body has, right? The so-called Equality Act was put forward in this body multiple times to add gender identity to Title VII and to our civil rights law generally. That law didn't pass. And so what we have are a series of agencies, whether it's the Department of Education or the EEOC, putting out either guidance or regulation that does what they weren't able to do politically. And I think they can't do it politically because of exactly what you said. Americans don't believe that the reality of biological sex is bigotry.